we have on various occasions, my Lord, intimated that we would like to show the footage that deals with that aspect, as well as the hand up the affidavit of the witness from ENCA who deals with this aspect. We have conferred, my Lord, with our colleagues regarding this aspect, and with a view to seeing if we can perhaps invoke the provisions of Section 213 of the Criminal Procedure Act to hand the footage by consent. However, my colleagues, and subject to confirmation by them, indicated that they are not going to consent to the admission of this affidavit. We therefore have to call this witness. The witness is not here today, my Lord. We hope to secure his attendance in due course. We're in discussion with his legal representative. He was subpoenaed to attend court on the 17th of June, 2025. However, he was excused from attending court and being present, as at that time, my Lord, we're still in negotiations with the defense. And since we could not reach consensus, we will have to call this witness, my Lord. We would like to show the footage today, my Lord. And we are going to rely on the provisions of Section 3 of the Hearsay Act. And the reason, my Lord, why we want to show the footage at this stage is we would like Brigadier Gininda to comment on the on the footage. And may I just briefly refer then to Section 3 of the Law of Evidence Amendment Act 45 of 1988. Which provides as follows. Section 3, hearsay evidence, says, subject to the provisions of any other law, hearsay evidence shall not be admitted as evidence at criminal proceedings or civil proceedings unless, and we are going to refer to subsection 3, which is relevant here. It says, hearsay evidence may be provisionally admitted in terms of subsection 1B. And section 1B reads that the person upon whose credibility the probative value of such evidence depends himself testifies at such proceedings. Now, subsection 3 reads that hearsay evidence may be provisionally admitted in terms of section 1B if the court is informed that the person upon whose credibility the probative value of such evidence depends himself testifies in such proceedings, provided that if such person does not later testify in such proceedings, the hearsay evidence shall be left out of account unless the hearsay evidence is admitted in terms of paragraph A. And paragraph A says that each party against whom the evidence is to be adduced agrees to the admission thereof as evidence in such proceedings. Or subsection 1. Subsection 1, basically, my lord, gives the discretion to the court to admit hearsay evidence after having had regard to the nature of the proceedings, the nature of the evidence, the purpose for which the evidence is tendered, the probative value of the evidence, the reason why evidence is not given by the person upon whose credibility the probative value of such evidence depends, and any prejudice to a party which the admission of such evidence might entail, and lastly, any other factor which should, in the opinion of the court, be taken into account. Now, subsection 4 defines hearsay evidence as follows. Hearsay evidence means evidence, whether oral or in writing, the probative value of which depends upon the credibility of any other person other than the person giving such evidence. Now, my lord, as indicated, would like to show the footage which deals with the proposition that was put by Mr. Mngumezulu. And we see that in the proceedings of the 28th of August, 2024. And my lord, I'm just going to read out the proposition just merely to show relevance, you know, and not for any other purpose, my lord. During the proceedings of the 28th of August, 2024, page 11, line 19, Mr. Mngumezulu. All right, let me put this version to you. According to those witnesses that I do not want to disclose at this stage, 3 shots were fired. 1 shot is the one that caused injury to Zandi on her leg. The other shot is the one that Longwe Twala shot himself on the leg while they were struggling for the gun. The third one is the one that shot Senzo Meyiwa, but I'm not mentioning them according to the sequence, how they happened. I mean, all these 3 shots, they caused injury to Zandi. The one was stuck in the ankle of Longwe Twala, and the other one is the one that shot Senzo dead. Then in line 10 on page 12, Mr. Mngumezulu, Longwe, after that incident, that wound became septic, and he went to a doctor, the late Dr. Mbatsani, who referred Longwe Twala to Dr. Mnisi in Ren Hospital, where a bullet was taken from Longwe's foot. Now, my lord, the purpose of this footage is to deal with this proposition. I will then, my lord, maybe just allow my colleagues to make submissions if they have any submissions to make in the in this regard.
Yes, Mnisi.
As it pleases the court, my lord, the first aspect that is stayed intimated that it is that it would wish to call the dentist who examined Mr. Sibia, Mr. Mnube, and whose report is already before court, and the state is basing that on the argument that in every circumstances the state has a first pick on witnesses. That is a gross misrepresentation of facts, my lord. This witness, for starters, Dr. Ali, is nowhere seen in the list of state witnesses. The state can only have a pick of witnesses when they specifically state the name of that witness in their list of state witnesses in terms of Section 144 of the Criminal Procedure Act. Dr. Ali, it's none of those witnesses. The state argues that by virtue of the fact that Dr. Ali works for the state, he then automatically becomes their witness. It also does not work out like that, my lords. If the state wanted to use Dr. Ali as their witness, the state should have made it a point that Dr. Ali does what the defense requested him to do, which is to assess Mr. Mnube, and then the state comes and includes him, as one of its witnesses in the list of state witnesses. The state cannot simply say because he works for the state, then he therefore automatically becomes their witness. It does not work out like that, my lord. For the fact that this process was initiated by the defense, and the defense approached Dr. Ali, who is working for the state, that simply means that Dr. Ali has been requested by the defense to come and assist the court. Who made that request is the defense. Therefore, whose witness is that? Is the witness's defense. It's very simple, my lord. There are so many witnesses that we would have loved to consult, which witnesses are in, that the defense would have loved to consult, whose names are in the list of state witnesses. And we are quite certain that some of those witnesses would provide some evidence that is favorable to the defense. That's an open secret. But for now, we'll not be able to do that because those witnesses are in the list of, their names are in the list of state witnesses. We can't even go near them. Exactly that is what the state wants to do. It's like the defense has got its own list of witnesses and say, this is our list of witnesses. And then the defense comes and say, no, but that one is working for the state. It can't be your witness because he's working for it. It does not work out like that. He's our witness. I think the proposal by the defense, by the state, that in an event that we choose not to call Dr. Ali to come and testify in the defense case, because it's our witness, then the state is going to make an application in terms of 186 to request the court, in the interest of justice, to have Dr. Ali called. But the state cannot call him. How will they then be in a position to interview our own witness? That will be a very gross irregularity, my lord. If that is what the state wants to do, state must stand up and say it also allows us the opportunity to interview the witnesses at this very same moment that they will not be utilizing later on, even before they close their state's case. I know the state will not do that because that is unprocedural. They are not yet our witnesses. They are still part of the state's witnesses. They have not been disclosed to us. The state does not even say to us, will you be calling Dr. Ali? Are you amenable to disclose Dr. Ali to us? The state simply says that, no, I want to call that witness because he's working for the state, and simply because he's working for the state, then we've got a first preference. It does not work out like that is a very gross, that will be a very gross irregularity of a procedure, my lord. Thank you. I think the last aspect, the 186, it covers everything, my lords. That's just my submission in the first instance, my lords. Now, with regard to the proposition that, I'm not so sure if the, thank you, my lord. Now, with regard to the proposition that was put by Mr. Mngomezulu on some of the witness here, it is indeed so, my lord, that upon being approached by the state, we recorded our vehement objection to the procedure that the state wanted to adopt or to employ. And basically the state, my lord, does not give the court the background of what is happening here. Remember Mr. Mngomezulu said, as per the quotation that has been read on record today, Longwe was one of the people who apparently got injured in the house. Now the state wants to refute that allegation. Now the state says, we want to refute that allegation by showing a video that shows Longwe that the following day, that's the information that we got from the state, that the following day, Longwe was seen walking very straight, he was not limping, and which is an indication that he could not have been injured on the 26th, because on the 27th, he was seen, he's been seen on the video, he's walking very straight, he's not limping. But that on its own has got its own challenges, my lord. And the state says, no, we got a clip of a video from ANC, ENCA, yes, I'm sorry, from ENCA. We got a clip of a video that will demonstrate that Longwe immediately on the 27th he was seen walking. But that has got various challenges, my lord. And those challenges are as follows. Just before I get to those challenges. The state says, no, we want to rely on exceptions to the hearsay rule. We want to lead this evidence on a provisional basis and allow the brigadier here to opine on the content of the video itself. And the state is saying it will be in the interest of justice that such videos should be shown and therefore allow Brigadier Kininda to opine. The state does not even say that after the acceptance or the admission of this hearsay evidence on a provisional basis, what would then happen with regard to it being accepted as part of the record? Finally, it does not say to the court what is going to happen to that, but now these are the challenges that I mentioned earlier on, my lord. Number one, the statement, the 212 statement or the 213 statement that the state says was penned by, that the state said it received, and it is through that statement that it wants to introduce this video. It is a statement by a certain gentleman known as Mr. Bailey. We got that statement. Now, Mr. Bailey simply says to the state, on paragraph 5 of his affidavit, this is what he says, and he says it emphatically. He says, on paragraph 5, I have no personal knowledge relating to the presence of Mr. Twala at the home of Ms. Kumalo on the 27th of October 2014, as I was not present at a residence. In fact, at the time I was not working in South Africa. I was in fact working in China. To repeat, I have no personal knowledge regarding the events, people or places depicted in the footage that is requested. So how does then Mr. Bailey assist the court here? because he simply addresses the question that we are taking up as an issue with the state. Number one, how are we going to know as to when that video was taken? Who will come and tell this court that, no, this video was actually taken on such and such and such a day, on the 27th of October 2014? Who will come and say that? Who took that video? Under what circumstances? Why was that video actually taken? Those are all the things that the state is hiding from the court. But more importantly, my lord, more importantly, the state says that the probative value of this video, which is hearsay, lies on Mr. Bailey. Mr. Bailey says, no, it can't lie on me because I was not present at the residence. I was working in China. And it says to repeat, I have no personal knowledge regarding the events, the people or places that are depicted in the footage. How can it then be argued that the probative value of this video that Mr. Bailey distances himself from can lie on Mr. Bailey? It is worse with Brigadier Kininda. It is even worse with Brigadier Kininda. He will be called upon to give evidence or to give an opinion on something which the court will, something that the court will not even know. Where does this thing come from? For starters, we don't even know where was this video taken, whether it was taken at the hostel, whether it was taken at the tavern, whether it was, because we've seen the video. It's a 5-second clip of a video. Or 34 seconds, yes. It's a 34-second clip video. Where it was taken, we don't know. For what purpose, we don't know. But my lord, this is what should concern the court very attentively. Mr. Longwe, he's one of the state witnesses that is mentioned in the indictment. Let me repeat again. Mr. Longwe is one of the state witnesses who is mentioned in the list of state witnesses in terms of Section 144 of the Criminal Procedure Act. The state, by simply including him in the list of state witnesses, gave out an impression that if circumstances were to arise that Mr. Longwe should come testify, we'll definitely call him. Therefore, you as a defense, stay away from him, because as of now, he's our witness. Now, the question that begs this court is, and that should actually trouble the court, my lord, very gravely so. Mentioning Longwe in the list of state witnesses, that is the person on whose probative value on what is happening on that video lies. It is only Longwe who can come and tell this court, yeah, no. Actually, the state does not even have to call that video. It does not even have to play that video. It simply has got to say to Longwe, Mr. Mngomezulu made these allegations to you that as and when this incident happened on the 26th of October 2014, you also got injured on your feet. Those are the allegations that Mr. Mngomezulu put to one of the witnesses. Do you agree with those allegations or not? And then he comes and tells this guy, I know, I never got injured today. Mr. Mngomezulu probably, I don't know, got that version from. That's the best evidence rule. Why is the state afraid? Or avoiding, really not afraid? Why the state avoiding to call Mr. Longwe, my lord? Longwe Twala. Why is the state afraid? I have tried to come up with speculation and answers to which ingenuity may suggest. I can only think, my lord, and I'll be forgiven for thinking that the state is afraid that Mr. Longwe comes here. He says, no, I never got injured on that day. But beyond that, let me tell you how this incident happened. Actually, the firearm that was used on that day was not a 9mm, it was a revolver. That's just a speculation.
This court can't listen to speculation.
Yes, thank you, my lord. But the gist of the question is, why is the state avoiding to call Longwe? The state does not say Longwe is no longer available. The state does not say that Longwe is untraceable. He is still there. That is the person on whose credibility and the probative value of what is depicted on that video lies, my lord. I would therefore strongly object in the strongest terms that that video should be played here and for Brigadier Kininda to come and opine on that video. What will he be saying? And in fact, the court has just indicated that it does not want to listen to speculation. All that Brigadier Kininda is going to say will be speculation, my lord. Thank you.
Yes, sir.
Sorry, my lord. May I just summarize
Now
everything?
let's the defense finish, and then you
As a
summarize for all three.
As the court pleases, my lord.
As the court pleases, my lord, two submissions really. The first one pertains to the applicability of Section 3, subsection 3 of the Hearsay Evidence Act 45 of 1988. And I say, my lord, with the greatest respect to Advocate Baloyi, that does not find applicability, my lord. My lord, we will have learned from the Baleka cases, the Singh, the Ramgobin, that video evidence is real evidence, and generally it is not considered hearsay. Hearsay will only arise, my lord, if in the video the persons depicted are making statements, and those persons are not available to come and confirm the statements that they made in that video. Otherwise, it is real evidence. There's no hearsay act applicable here, and I'll tell the court why. Mr. Mnisi has introduced, by way of submission, what we have seen in that video. That video is a 34-second video, my lord. It does not show any person uttering anything, or at least it is not audible what the utterances are being made. For that reason, my lord, I'll say the Hearsay Act does not assist the state in trying to bring Longwe's evidence via the back door, via Mr. Bailey, who says, in fact, what he obtained was not a video of 27 October 2014, but it's a broadcast of 10 October 2024. That was a rebroadcast, and it contains the subject matter of the subpoena that was served upon him by the state. He does not say it contains this footage. He says the subject matter of the subpoena. I don't know what the subject matter is. The state will clarify that for the court. I'm not privy to the subpoena that was served. It was never disclosed to us, my lord, and I don't think we also belong in the serving of that subpoena, my lord. Now, with video footage, my lord, it needs to be authenticated that it represents accurately what it purports to be depicting. Now, if only that it shows its action and not words, no oral utterances, I'm still standing, my lord, that Without utterances, the Hearsay Act does not apply, my lord. Now, the second aspect, my lord, is, and just to concretize this point, is the one that Mr. Mnisi touches on. Mr. Longwe Twala is alive, my lord. In fact, my lord, if I go back in 2023, before Mr. Host testified, we received an email from Advocate Baloyi informing us that we must prepare that because they were going to call, amongst others, that Monday, Longwe Twala, Jack Buthelezi, and Mr. Host, Colonel Host. And about 10 was made later to say, no, prepare only for Jack Buthelezi and Mr. Host, my lord. I understand, my lord. I've been practicing for 100 years. The state is dominus litis. Why they decided at the last minute to withdraw Mr. Longwe to come and testify is their own prerogative, my lord. But the point that I'm making, he's still alive and kicking. And but by what we have read in the media, my lord, he's sobering up from whatever is afflicting him. So he's a compellable witness to be called and testify on this aspect, whether or not he was shot at and injured on the 26th of October 2014, my lord. My lord asked me the other day whether I read Canadian law, and there's an important term that was mentioned there by one of the judges, and so Pinka was also in that judgment, which says a witness like Mr. Gininda for this purpose is not going to assist the court and ourselves, my lord, to know that the person depicted on that video is Longwe Twala. I don't know Longwe Twala. The court does not know Longwe Twala. My colleagues, I believe, they don't know Longwe Twala. We are going to listen to the say-so of Mr. Gininda that this is Longwe Twala. That, my lord, in Canada has been held to be a supererogatory and unnecessary evidence by Sopinka. So, Advocate Baloyi is inviting this court to listen to the most superfluous evidence that will come from Brigadier Gininda, with the utmost respect. Brigadier Gininda is not going to assist the court in that respect, my lord. So I submit, my lord, and vehemently so as well, that this video should not be played in court until it's authenticated by the relevant people under oath, my lord. Not through the Hearsay Act that is not applicable, not through the superfluous evidence of a lay opinion of Mr. Gininda, my lord. Brigadier Gininda, I'm sorry, my lord. As the court pleases, those are my submissions, my lord.
Yes, Mr. Kamumalo.
Thank you, my lord. The first issue that I want to address is the issue of the witness. Dr. Ali.
Yeah.
My lord, the stage at which the state can boldly say that that witness is theirs has gone past because of the propositions that were put by my learned colleague, Advocate Mnisi, to Sergeant Mabasa under cross-examination. There's versions, there's propositions, there's the contents of the report that was put to Sergeant Mabasa by my colleague during cross-examination. So the state cannot say now that that witness can be called by them. That is the state, because it will be ran parallel. The defense is calling the witness. On the same breath, the state wants to call that witness to testify on the very same issues that the defense has raised. So that is totally unacceptable. On the issue of the video, firstly, I wish to mention, my lord, that there is no change statements in respect of what happened after that video was taken, where it was stored, up to the stage when it was played by or handed to the state for them to use it in this trial. We don't have even the statement of a person who took that video. We don't know when it was taken and the time when it was taken. Safe to say that we were told that that video was taken on the 27th of October, 2014. that is the following day. The person who is depicted on the video, I'm instructed by my client that he doesn't know that person. As to why that person is not called here in court to come and testify, we don't know. It is my submission, my Lord, that the applicability of the Hearsay Act is not relevant in this application or the submission by the state, because we don't have anything. We don't have affidavit in support of the video. As I've indicated, my Lord, we don't have chain statements of the person who took the video as to where it was stored, and the person who is depicted on the video to say that he is indeed the person who is there. We don't have such. So it cannot be said that the applicability of the Hearsay Act is relevant in this aspect. And again, my Lord, in this matter, I can say it without any reservation, because I can see that time is against us. We seem to be going in circles, my Lord. The assertions by Mr. Mgomezulu were raised in this court on the 28th of August, 2024, some 10 months. As to why this was not pursued after Mr. Mgomezulu, may his soul rest in peace, was not followed, the issue of the video was not followed, we don't know. Because one would have assumed that after such assertions were made by Mr. Mgomezulu, then the state was going to pursue the issue of the video, to lead that evidence. But now it wants to lead that evidence through Brigadier Gininda, of which when the matter was adjourned on Monday to today, we had expected that Brigadier Gininda was going to be re-examined on the aspect of the application that was granted by this court, having been made on the 17th of June, 2025. So I really must say, my Lord, that we seem not to be making any progress in this matter. Thank you.
Yeah, can interpret.
Bafowethu ke kade kunodaba lana kade sikhuluma ke ngalo noma kade ihlangothi noma ithimbakela abashushisi ebaqhamukisile kudaba lakhona ukuthi eBrigadier Gininda bambizile ukuthi azokhuluma amaphicelezi nodaba loluyithombe kade iqhamukile la ngaphambi kwenkosi yenkantolo ke lezi kade bejijobulela njengofakazi ubushaka lapho ke la kade bekhuluma khona ukuthi baletha ke lapho kumnumzana warrant officer Ndlovu futhi nomnumzana oSergeant Mabasa ke ekuthize baletha ufakazi babo phicelezi nodaba loluyithombe ke lapho ke bese ngemuva kwalokho bese babiza kumnumzana uBrigadier Gininda ukuthi zina azojobela ke azokhuluma phicelezi nodaba lolonke kepha ke khona ke inkulumo iqhamukile ke lapho ke khuluma ngayo ehlangothi lethimba labashushisi elukhulume ngayo ke lathi khona ke njalo lapho ke khona ke inkulumo yakhulunywa ke lapho umnumzana sele washona ke lapho umnumzana Mngomezulu ke lapho ke phecelezi nodaba lofakazi malana nodaba lwevideo kade beshicelele lapho ke basho khona nje kungaphansi kozomthetho ke lapho ke section 213 thizeni ke umnumzana uBrigadier Gininda bambuze ke imibuzo phecelezi nodaba lwevideo khona uthi video khona dlala ka 34 wama seconds ke lapho ke bathi futhi video khona kujangala khona ke lapho kulonga ithwala ngesikhathi kade hamba khona ke lapho ke bathi futhi umnumzana uMngomezulu sele washona ke kunenkulumo awayikhuluma ukuthi lapho ke ngesikhathi kade khona ke udlame kulokho lomuzo namhlanje esigameko ke ngaphakathi kwalomuzo lapho kwakhumalo ke lapho ke kwadutshula khona ke lapho ke uLongwe onyaweni lwakhe ke futhi nozanda thola ukulimala lapho ke bese ke enye ke inhlamvu lapho ke bese yashaya ke lapho ke uSenzo ngesikhathi bekashona khona ke lapho ke kepha wathi umnumzana Mngomezulu inkulumo yakhe akaze ayikhuluma ukuthi ubani uqala wadutshula ke lapho ke bese kwalandela abantu ngemuva kokuqala bese osibili nokusithathu ke lapho ke kepha ke bese lapho abameli benu othola isikhathi sokuthi nabo baphenduleke mana nesicelo lesi kade sethola ubaba olokozana umnumzana ustate lapho sithi umshushisi kade ayikhuluma ngesikhathi bekaletha inkulumo yakhe lapho ke bese waphakama washo khona njalo lapho ke umnumzana Mnisi ke ukuthi ngesikhathi bekaphendula mana phicelezi nenkulumo lebekhuluma ke umnumzana obalo ke lapho kumele uhla ithimba labashushisi ke lapho ke washo khona wathi udokotela uAli ke lapho ke ufakazi ke wabo ke lapho ke ngoba kusase yena ufakazi ohlangothi noma ithimba labashushisi ke lapho ke ngoba uyena sele bamsebenzisile ke lapho ke futhi yena osebenza ngaphansi kwesikhungo ke lapho ke sakahulumeni ke laba abenza khona ke inhlolo zabo ke zamazinyo ke lapho sho i-dentist ke leyo ke la kade umnumzana Ncube aye khona ke ngesikhathi ade bamhlola kamazinyo wakhe ke phecelezi nodaba lwezinyo legolide leli bathi kade analo ithimba labeshushisi ke lapho ke kule thombi lezade ziqhamukile bebelethe ufakazi bazo ke lapho ke umnumzana Warrant Officer Ndlovu futhi nomnumzana olokuzana uSergeant Mabasa ke lapho ke bese babuya bakhuluma ke khona njalo bathi ngeke kukhonakala ukuthi udokotela bambize futhi abizwe ithimba labashushisi ke lapho ke ithizini alethe kufakazi bakhe ke lapho ke ngoba wona sele bamsebenzisile futhi oqedile ngofakazi bakhe ke lapho ke wabuya washo khona njalo ukuthi ngeke bakhona ukuthi abize kudokotela ngoba bakhona futhi abanye abofakazi ke abawela ngaphansi kwethimba labeshushisi ke lapho ke nabo angafisa ukuthi bababize bese bezeke ngaphambi kwesenkantolo ke uma sebabiza kushila bona ke bangaze bahambisane nohlangothi ke uma ngabe bethula kufakazi babo ke lapho ke futhi washo khona njalo wathi melana nodaba lolo lakhulunywa kumnumzana uNgomezulu ke ngesikhathi kade abuza imibuzo ke kubufakazi labo ke yena ke bathi washo khona njalo ukuthi ke yebo ushonge umunye wabantu abalimala ke bekhona ke ngaphakathi kwalomuzi loyana ke futhi ke kepha lapho ke ithimba labeshushisi kade ngesikhathi esanele lokuthi lapho ke bahlale phansi naye lo ngokukhulumisana naye ke bese bamlungise lapho ke ekuthizeni eze alethe ufakazi bakhe la ngaphambi kungusenkantolo ke bathi khona njalo malana nodaba lwevideo lakhe leli kade bekhuluma ngalo ke ithimba labeshushisi bethi bangathanda ukuthi bayijengise la ngaphambi kungusenkantolo ke bathi kuvideo khona asizwa awukho umsindo ozwakalayo ke ngemuva kwevideo yakhona ke kepha sibona nje umuntu eyihambela ke lapho ke futhi abanasiqiniseko ukuthi ngabe uLongwe loyo ke noma kusiyena ke uLongwe futhi wabuya bakhuluma futhi bathi khona njalo malana nodaba lwevideo ke leyo ke asiyazi ukuthi ubani owathubula ke video yakhona ke ngaphansi kwesimo esinjani ke futhi ethubula kuphi ke video yakhona ke futhi azikho i-statement ezabhalwa ngaphansi kohlelo lwafidaviti ehambisana nohlelo lwevideo yakhona ke lapho ke futhi basho khona bathi uDr Ali ke lapho uDr Beli ke lapho ke wakhuluma ukuthi akanalo ulwazi lokuthi yini eyenzeka ngaphakathi kwalomuzi lena ngelanga lenge-26 futhi ngelanga lenge-27 ngoba kade angekho la eNingizimu Afrika kade ahambile kumsebenzi sebenzela kwizwe laseShayina ke lapho ke ngesikhathi sade ekhuluma ngevideo lena ke futhi washo khona njalo thina akanalo ulwazi lwale video lena ukuthi ngabe ubani ukhona kule video lena futhi ukuthi video khona bayithubula kuphi ke nendawo kade futhi ubani kade akhona ke ngaphakathi kule video leyo ke bese wakhuluma khona njalo lapho umnumzana Mnisi ngesikhathi wakhuluma ke inkulumo yakhe eningi lapho ke waqhubeka washo khona njalo asazi ukuthi ubani uthubula ivideo yakhona ke ubani bathathe kuphi ivideo yakhona futhi ngaphansi kwezimo ezinjani ke manje kuza kanjani ukuthi uLongwe Twala ngoba usaphila usangakashoni ke kuza kanjani ukuthi ithimba labashushisi lengambizi ezela ngaphambi kwesenkantolo ke njengofakazi bese ethula ufakazi bakhe ke lapho ke bese bambuza imibuzo phecelezi nodaba levideo uma ngabe sebesitshengisana ke lana kulesikhangiso lesi suthi sakamabona kude ke lapho ke washo khona njalo ukuthi ngeke bakhona ukuthi babuzeke lapho ke ubaba Brigadier Gininda ngofakazi bale video leyana ke ngoba ke lapho ke yena ke akanalo ulwazi bevideo yakhona ukuthi ngobani wathatha ivideo basika kuphi lapho umuntu angasilekelela phecelezi nodaba levideo leke bathi uLongwe Twala ke lapho ke bese wabuya futhi wakhuluma ke lapho umnumzana uRamsepili naye ke ngesikhathi bekakhuluma bekahambisana nenkulumo bethule ke lapho ke umnumzana uMnisi ke lapho ke washo naye washo ocishe kwafana ke ngamashina lokho akhulumile lapho ke umnumzana uMnisi ke ukuthi ivideo khona akasazi ukuthi bathatha nini ke futhi uthatha kuphi ke nendawo futhi ubani okhona ngaphakathi kule video khona ke futhi nabantu abamelele nomuntu amela ngaphambi kwenkosi enkantolo ke ushilo ukuthi akamazi lo muntu abamtshengisile kule video ukuthi ubani ke lapho ke futhi inkosi enkantolo ayazi ukuthi ubani okhona ngaphakathi kule video yakhona ke lapho ke kepha umnumzana uBrigadier Gininda angeke akhone ukukhuluma ngento anganalo ulwazi layo ke suthi isikhangiso sale video edlala ke imizuzwana ewu34 ke lapho ke futhi washo kwenza ukuthi udokotela ngesikhathi bekathola kamaphepha ke lawo bathola ngelanga lange-10 ka-October ke lapho ke ngemuva kokuthi le video lesesele beyithathile ke lapho ke futhi ade besola ukuthi video khona bayithatha ngelanga lange-27 ka-October la kade khona ke uLongwe ehamba kahle ke suthi bekangena lutho enyaweni lakhe ke ngemuva ukuthi bathi khona ke la abadubuleka khona ke nangesikhathi isade kudutshula lapha kule ndawo lena yesigameko esaphakama futhi khona njalo ke lapho kumnumzana lapho unqumalo naye uthi ahambisana ke nenkulumo yabameli abayikhulumile ukuthi umnumzana ke Brigadier Gininda angeke akhona ukuletha ufakazi bakhe mayelana nevideo lena ke ithimba labashushisi abakhuluma ngako ngoba ke abukho ufakazi obuhambisana nevidiyo okusitshengisa ukuthi ividiyo bayithwebula kuphi-ke nendawo bayithwebula kuphi futhi athwetshulwa ubanike lapho-ke kusho ufakazi obhaliwe ngaphansi kodaba lwesifungo sokuthi ama-affidavit abhaliwe lapho-ke ahambisana nenkulumo yale vidiyo noma mhlawumbe aphelekeza-ke ividiyo yakhona la isitshela khona ukuthi ividiyo athwetshulwa umuntu othizeni wakuphi nendawo uhlala ngaphansi kwekhililiphike lapho-ke wathwebula kuphi-ke nendawo futhi wakhuluma khona njalo bathi lapho-ke futhi washo khona njalo naye ukuthi lapho-ke umuntu amele umnumzane Maphisa uthi naye akayazi ukuthi ubani-ke lo mlisa ujakala ngaphakathi kula vidiyo lena kusho lo muntu bamthwebuleke lapho-ke ividiyo yakhona-ke bathi abazi ukuthi ubani-ke leyo futhi akukho ama-statement athathiwe lapho-ke aphelekeza ividiyo lena ukuthi basitshela lapho ukuthi ividiyo bayithwebula kuphi-ke nendawo kanjani futhi angaphansi kwezimo ezinjani yilokho kade bekhuluma ngako-ke lapho-ke.
Can you respond, Mr. Chair?
As you could please, my lord. I think it's crucial to distinguish between two concepts. The first one is relevance, and the second one is the weight to be attached to the evidence. And I think what my colleagues have put emphasis on is the weight to be attached to the evidence. But the first hurdle, my lord, is relevance. Evidence can only be admitted if it's relevant. And at this point in time, the question is whether is the evidence relevant? And we submit, my lord, that it is relevant. The court has previously referred to section 210 of the Criminal Procedure Act, which reads that no evidence as to any fact, matter, or thing shall be admissible which is irrelevant or immaterial and which cannot conduce to prove or disprove any point of fact in issue in criminal proceedings. Now, we have argued in the past, my lord, that we have facts that are in issue, and the Latin term that is sometimes used is the facta probandum. And you have facta probantia. You know, those are the facts that you use to prove the facts that are in dispute. Now, you can only lead a fact to prove a fact that is in dispute if that fact is relevant. And we submit, my lord, that the evidence is relevant. And I want to deal with the submission of Mr. Ramsipili that this is Section 3 of the Hearsay Evidence Act is not applicable. And I think that aspect was also touched upon by Mr. Numalo. The fact is this, you can have real evidence, which is the footage itself, but if you want to prove the contents of that footage, that becomes documentary evidence. And I think that is where my learned friends, with the greatest of respect, miss the point. And once you want to prove the contents of a real exhibit, as I indicated, that becomes documentary evidence. And you can only prove documentary evidence through three means: by calling the author. Firstly, the documentary evidence must be relevant. And secondly, you must call the author to prove the contents thereof. And thirdly, you must prove the authenticity of the documentary evidence. And that is precisely, my lord, what the state seeks to do. The court will remember in the olden days when there were illegal gatherings were prohibited. Tape recording is made of the proceedings. Someone would come, a policeman will always come and say, the video will be played, and they'll come and say, so-and-so on that video, it's accused so-and-so, and the person on the video is accused so-and-so, you know. That is when you prove the contents of real evidence.
sorry.
Mr. Numalo questioned as to why the state took long to present the evidence. We have, on the previous occasion, my lord, indicated that there's a certain procedure that you must follow if you want to tender evidence from media houses. We indicated, my lord, that there's an agreement between South African National Editors Forum and the law enforcement agencies that you have to follow a certain process if you issue a subpoena. And we did indicate in this court, my lord, that we started this process as far back as December 2024 in securing the subpoena, because the subpoena must be authorized by the National Director of Public Prosecutions, and thereafter the matter then goes to a local magistrate in Boksburg, and a subpoena is then issued. That is the route that we followed in the current instance. As far as the submissions of Advocate Mnisi are concerned, I think we did indicate, my lord, that we're not really pursuing the issue of the dentist any further. I thought the matter will then be left at that. But he also, with the greatest respect, my lord, submitted that there was also this obfuscation between relevance and the weight to be attached to the evidence. And I think, with the greatest of respect, Advocate Mnisi was arguing the weight that should be attached to the evidence. He mentioned that Mr. Bailey states in the affidavit that he bears no knowledge of the events. He was in China, but it's not about that, my lord. It's about the authenticity and reliability of the footage, and that's where Mr. Bailey comes in.
Sorry, is he the person in charge?
He's the news editor.
The news editor.
Yeah, he's the news editor at ENCA, under whose custody the material is archived. And again, to deal with the issue that was raised by Mr. Ramusipel as well as Advocate Mnisi about the fact that this evidence that can be of no assistance to the court, except if Mr. Longwe Twala is called. Well, two submissions in this regard. Firstly, a matter is decided on direct evidence or also on circumstantial evidence. And there's nothing that debars Brigadier Gininda if he can identify a person on a video to state as to who that person is. We've just been through that exercise, my lord, with the photos, where the witness would look at the photo and state what they can observe on the photos. That's perfectly permissible, my lord. But as to the question as to why the state is not calling Mr. Longwe Twala, my lord, the state doesn't have to call every witness whose name appears on the list. If at the conclusion of the state case a witness is not called, it's up to the defense to call that witness. We therefore submit, my lord, that the footage is relevant, and we have sketched the background as to why it is relevant, the proposition that was made by Mr. Mgumezulu, and that it should therefore be admitted as evidence at this point, subject to the proviso that we've mentioned in subsection 3 of the Evidence Act, my lord. This is as far as we can take our submissions, my lord.
Yeah, but just for fulsomeness, the court has still got to decide, I'm with you, to decide whether it is in the interest of justice. Is that not a supervening ratio in the
Yes,
in
well,
section 3?
yes, well, if for whatever reason that witness is not available, the court then can, in the interest of justice, decide to admit such evidence.
But still, the defense can argue that evidence is prejudicial or it is not in the interest of justice. Is that not so?
Well, they can do that.
Yeah,
Ma'am,
fine.
But that will be at the end.
That's it.
Yeah, at the end of the case,
Of the
you know,
case, yeah.
about the weight that should be attached to the
Yeah, fine.
evidence. But at this point, the question is the evidence relevant?
And as far as Longwe is concerned, if the state doesn't call him,
Well,
the law says you must advise the state,
the defense. Yes.
that you're not going to call him, and then the defense can use him if they
Yes.
want to.
Yes, indeed, my lord. That is the legal position.
Yeah, but my interest, okay, fine. Are you through?
Yes. I'm through.
What is the status of this Exhibit SE, Mr. Mnisi? The report of the doctor, what is the status?
Thank you, Madam.
Because I hear you arguing about evidence.
Yes.
So I want to know, what is the status of this document?
I requested that should be admitted as an exhibit, and it got admitted as SE. We have to hear from the state whether they are disputing the content of this report, in which event, then in our case, when we conduct our case, if we actually come to that stage, because I've got a strong feeling that we'll never even get there, we will then try to decipher whether or not to call this witness, my lord.
Which
But
one?
I haven't had an indication from the state that they're
No, the state
disputing the
wanted to call
content.
the Dr. Ali. Did you want to do that? Yes. That's why I'm asking.
As I've said, my lord, Dr. Ali
Is
is
your
a
witness?
witness.
Yeah,
Yes.
yeah, they can't
Yes.
get away from the fact that Dr.
Yes.
Ali is the defense's witness.
Yes, my lord.
But you see, you have presented a document
Yes, my
by
lord.
Dr. Ali.
Yes.
It was not handed in through the evidence of Dr. Ali. Are you with me?
That is so, my
That's
lord.
it.
Yes.
Now, as far as this court is concerned, this document is not before it. Am I correct? Because this is Dr. Ali's document.
No, the document is provisionally before court, my
You
lord.
didn't say that. You didn't say that.
I thought the court would
No, no.
basically be very proactive in that
I'm aware
regard.
of
my lord.
everything.
Yes,
That's why I say it's different if Dr. Ali makes an affidavit.
yes.
I'm a doctor, blah, 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 and he hands it in.
Thank you, my lord.
But as it is, what is the status of this document?
It's not a train smash,
Is
my
it
lord.
evidence? It's admissible evidence at this stage?
My lord, the document contains issues that were put to the witness relating to the teeth. Yes.
Whose
So,
evidence is that? Dr. Ali's?
no, that was the evidence of Mabasa.
Yeah, fine.
Yes.
And how do you counter it? By presenting this document. I heard you say to the witness yesterday, in your layman's opinion.
Yes,
Fine.
yes.
Okay, I'll make a ruling, but I'm just making a way. This document has not been properly handed up
Thank you, my lord. Thank you.
because that's not a way to hand up documents.
Thank you, my lord. Thank you.
Yeah, and then the other thing, Mr. Ramosepedi, you're saying it's not in the interest of justice for this court to view the clip. It's not in the interest of justice. Or actually you are saying the Evidence Act doesn't allow that.
My Lord, I'm interpreting.
Let's start here. Does the Evidence Act allow such a procedure?
My submission is that it does not, my Lord.
It does not.
It does not.
Which section is that?
Section 3,
Read it.
subsection.
Yeah, read it.
Yes, PA. You must put on your specs if the right is too small. What is it? Yeah, section 3, subsection 2, 3. Yeah, my eyesight is bad. It says, my Lord, section 3, sub 3. Hearsay evidence may be provisionally admitted in terms of subsections 1, sub B, if the court is informed that the person upon whose credibility the probative value of such evidence depends will himself testify at such sorry, my Lord, I said this best, will himself testify in such proceedings, provided that if such person does not testify in such proceedings, the hearsay evidence shall be left out of account unless the hearsay evidence is admitted in terms of paragraph. What paragraph is this? No, I can't see. In terms of
Paragraph A,
H.
small letter A
Yeah.
of subsection 1.
Yes.
Yeah, what does it say? That's paragraph H, subsection.
You don't have a CPA.
Doesn't it say if it's in the interest of justice, this court can provisionally allow that evidence? And subsequently, if that witness doesn't turn up,
Then it's
then
not
the
possible.
court can revisit.
Yes.
Yeah, so where's the prejudice for your clients?
My Lord, the two riders are, the court is quite correct. The one rider is the interest of justice. The other rider is the probative value. What probative value does
I don't know.
this evidence?
The state will have to argue that. I don't know.
That's the other thing, my Lord, that you are not told the probative value. Hence, I, in my submission, said it doesn't help the state.
When I take it, the
to argue
state,
hearsay
the state won't just call. This judge puts it like this.
I'm sorry, my Lord.
I said that the judge putting it, you don't call a motley of evidence for the judge to see what to do with it. If the state calls any evidence,
Yes.
it must be for a specific reason. So when Mr. Baloyi or Dr. Sibanda call evidence before this court, it must be typified by the fact that it's in pursuance of the case we are dealing with.
I understand the court, but my Lord, why will that then be inadmissible evidence?
Which evidence is inadmissible now?
If the court says they are bringing each and every evidence to court for a particular reason, there's some of the evidence that's been ruled inadmissible, but they brought it anyway.
Yeah, sometimes you do rule it out.
Yes. But my Lord, as well, before I finish on this point, Advocate Baloyi addressed the court on relevance, and it's quite correct. But if we go to I mean, the cases on relevance, CATS, Zuma, Torpedo on dog attacks and dog tracking, whatever. We are not saying that the evidence is not relevant,
What are you saying then?
my lord. There's a distinction.
Because the state is basically saying, wait, that evidence is relevant. And now you are telling me we are not saying that evidence is not relevant.
My lord, it's how evidence is procured and brought before court.
He says he's got a subpoena which he has served in terms of an agreement apparently which the South African police have with the news agencies.
Yes.
So that's how he says Bailey comes into the picture to authenticate.
Because the other misnomer that I had, my lord, from the response from my learned colleague was that this is documentary evidence. But if we read the two Balekas, where Van Dijk clearly says we mustn't confuse video footage evidence with documentary evidence, because on the latter, which is the video footage evidence, the best evidence rule does not even come, because you can introduce a copy if, for instance, the original has been lost, as long as also it can be authenticated as to originality. Authenticity goes only to weight, my lord. So we mustn't, according to the Balekas, that's what it says. That's the court pieces, my lord. Those are my submissions.
Yeah, having listened to the submissions and the counter submissions by the state, by the defense, I'm of the view that if the state argues that the evidence which it wants to lead now is relevant, then this court cannot deny the state to lead that evidence. Because the defense, in any event, if it feels it is prejudiced, they can cross-examine on the basis of the evidence being inadmissible. So consequently, the application is granted.
As the court pieces.
As a court piece, my lord.
besho khona njalo ke isinqumo sekusenkantolo mana lodaba lwabameli beligikida futhi uhlangana nethimba labashushisi ke lapho ke lethi uma ngaba ke ithimba labashushisi libona ukuthi kufanele ukuthi balethe ufakazi lobo abafisa ukuthi babuletheke lapho ke ithimba labameli benu kulithola isikhathi esisanele sokuthi zeni babuye futhi ke babuze imibuzo mayelana nofakazi lobo isihlangothi labashushisi ababulethayo manje ke lihambisana nethimba labashushisi thizini ithimba labashushisi ke iselaqhubeka ke lenza lo letha lofakazi lobu abafisa ukuthi babulethe.
So we didn't take the normal short adjournment. Are we proceeding or are we
What
going
time
to?
is it now?
It's 11:25.
Yeah, let's come back at 12. No? Sorry, at quarter to 12.